Okay, we'll wait for a few more people to join just before 2 o'clock. Good afternoon and welcome to another instalment of State Trustees webinar series. My name is Stuart Wilkinson, Relationship Manager here at State Trustees, and I'll be facilitating today's session on the do's and don'ts of writing your will. Before I introduce our experts, I'd like to begin today by acknowledging the traditional custodians of the land which we gather today, and pay my respects to elders past and present and emerging. I extend the respect to Aboriginal and Torres Strait Islanders peoples here today. Today we'll be joined by David and Jasmine, but I might leave it to them to introduce themselves. David, would you like to start?
Thanks, Stuart. Yes, my name's David Andrew. I've been with State Trustees for 15 years. My role is Senior Advisor, so I provide technical advice in respect to the area of state administration and assist with their more complex estates. So that's what I do.
Thank you. And Jasmine, over to you.
Hi, everybody. My name's Jasmine Berger. I'm a Senior Solicitor at State Trustees. I've been with State Trustees about 16 years, and at the moment I manage the estate litigation team. So we deal with disputes in relation to deceased estates. That would be claims for family provision, claims in regard to testamentary capacity, and sometimes just seeking clarity on what a will means.
Thank you. Certainly plenty of experience on the panel today. Today's sessions will be broken into two parts. The first section, I'll be asking David and Jasmine the most common will-related questions. And for part two, we'll be allowed some Q&A time at the end. So if you think of any questions, please type it in the chat box and we'll collate them and we'll try to answer as many as we can with the time that we have today. Don't worry if we don't get to your question. We'll be sending out answers to all the questions and a recording for this session for you to look back in your own time. For those of you that might be unfamiliar with State Trustees, State Trustees is a government-backed company that provides access to comprehensive legal and financial services to all Victorians. Since 1940, they've written over 250,000 wills and administer more deceased estates than any other company in Victoria. So it seems like a nice segue into the first question, which is for you, Jasmine. What is a will?
Okay, so a will is a legal document where you set out how you want your assets disposed of and how you want your estate to be dealt with. So for it to be legally enforceable, it needs to be clear and it needs to be in writing in Victoria.
And who can write it? Who can write a will in Australia?
Well, anybody over the age of 18 can actually write a will, provided they are of sound mind and have testamentary capacity. So testamentary capacity means that the person understands what a will is, what a will does, and they also understand the extent of their assets.
Good to know. David, does each state have different laws?
Yes, they do. As yet, we don't have uniform laws within Australia in the area of wills and estates, so each state has their own separate legislation. In respect to wills and estates, the states are reasonably consistent. I mean, there may be some differences in areas like claims and intestacy, but I think for today's session, the important point to make is a will that's made validly in any state or territory of Australia will be recognised in any other state or territory. So a will made properly here will be recognised elsewhere and vice versa.
You touched on it briefly. What makes a will legally valid?
Well, assuming that the person has full age or a full aging capacity, then the requirements to make a valid will are actually relatively modest. As Jasmine said, it must be a document in writing. It must be signed by the will maker. It must be witnessed by two witnesses who are present at the same time when the document is signed and made with the intention of being a will, but in essence, that's it. You don't need to call it a will. It doesn't need any special words. If it is in writing, if it is signed, if it's witnessed by two people, then that's the basic requirements for a valid will.
Thank you. Looks like there's a few questions coming through at the moment. Remember to pop any questions in the chat, and we'll get to those at the end. Jasmine, another one for you. Why do you need a will? And what happens if you pass away without a valid will?
Well, if you pass away without a valid will, then your estate will be distributed in accordance with the laws of intestacy. So that might mean that people get your assets that you would not have wanted. And that would mean also that someone else would administer your estate other than a person of your choosing. So it's far better to have a will, and so that you can set out exactly what you want, as opposed to all sorts of things happening that you might not have anticipated. Also, if you don't have a will, it'll take a much longer time to actually settle and wind up your estate. It will also be more expensive. So I strongly recommend that everybody, even if they don't have a lot of assets, set out their wishes in a will, and that will mean that the estate will be distributed as you have set out.
Yeah, so certainly, definitely something to consider. So we want to take on. We've decided to make a decision to write a will. What are some of the essential things you need to consider before writing a will?
Well, you'd want to consider who's going to administer your estate and who's going to be the executor of your estate. So you'd want to chat to somebody that you might have in mind and see if they'd be willing to take that on. The other thing you might consider is your assets. What assets do you actually have? Sometimes people might think they have an asset, but it's not in their name, and you can't gift something that doesn't belong to you. So it's a good idea to actually work out what belongs to you and how you want to dispose of that. The other thing you might think about is if you have minor children, once again, you'd want to think about who would be the guardians of those minors, and also have a chat to the person that you have in mind, because obviously that's a big responsibility. And you'd want to know that that person would be willing to take it on. And if they're not, then at least you can consider another option. The other thing you'd put in would be funeral instructions and your wishes. Some people have definite wishes in relation to whether they want to be cremated. And if that's the case, far better to make that clear in your will. The other things to think of would be if you have pets, who's going to take care of those pets, and what you can do to ensure that they're looked after when you pass away. For some people, pets are very, very important and they're part of your family. So you'd want to consider what to do when you're not there. The other thing you might consider is a gift to a charity, and set out who that charity is. The other thing you could consider would be gifting sentimental items to somebody special in your family. So those items might not have a high value in terms of money, but they might be important to you. So I'd suggest that you then put that in your will. So quite a lot of things to consider, but really important to turn your mind to them.
Definitely. So let's say, for example, I've dedicated the time and got all my ducks in a row. How do we get started with writing a will?
Well, it's actually really easy. You can just hop online, and it will take you half an hour, and you can do an online will. If you're not comfortable with doing that, or if your estate is a little bit more complex, then you can ring State Trustees or use our online booking system and make an appointment to see one of our will writers who can assist.
Fantastic. David, we're going to be tapping into your many years of experience here. What are the most common mistakes people make when writing a will?
Sure. Okay. Look, I'll raise a couple of different areas. Assuming that it's been properly signed and witnessed, the sort of mistakes I think people, or the things we need to turn our mind to, are things like the executor provisions, the choice of your executor, to make sure that you're selecting somebody who is willing and able to act, and also having a substitute executor provision. So if the first choice is unable to act for any reason, that there is someone else who can step into that role. So the executor provisions are important. I can sometimes see those being mucked up. It's important to have an effective remainder clause. And by a remainder clause, I mean a catch-all clause. I give the balance of my estate to A, B, C, and D. And what I'm trying to avoid is I see some wills where people try and gift each and every asset that they have. Now, it's not to say you can't gift assets, but if you try and cover every single asset, invariably you'll leave something out and you run the risk of a partial intestacy. So it's important to have a remainder clause where you make sure that nothing is missed out. I think they should also give thought to gift over clauses. Again, I'm referring to the balance of the estate. I give my whole estate or the balance of the estate to A. Well, what happens if A doesn't survive you for 30 days? Then we want to have some provision that it goes to someone else, and that's called a gift over clause. And that might be to A's children, but it doesn't have to be. It might be to the Lost Dogs Home or anybody. So at least to think about, if a provision doesn't, if provision fails, that there's someone else who can then get the benefit of that gift of your choosing. I think you also have to think of procedural things, like signing every page of the will, and using the same pen. Now, but using different pens or not signing each page doesn't make it invalid, but it just means that the registrar of probates will require more information on affidavit to be satisfied about certain things. So it adds a complication and an expense to your grant application. And probably lastly, just I'd say make sure that you properly store your will, your original will, somewhere where it's safe and secure, and also that somebody is aware as to where it is located. You're the only one who doesn't have to know where it is because you're gone, but someone else does have to. So I think executive clauses, a proper remainder clause, gift over provisions, signing each page in the same pen, and where it's stored are probably the things that I'd mention most, Stuart.
All right, David, at this point, I'm convinced I need to get a will.
Right.
Why choose State Trustees to write my will?
Well, I think the first point is, from my point of view, is that you should always get a professional will writer, in my view. It's a pretty important document, and it's to deal with your hard-earned assets built up over time. So go to a professional will writer, whether it happens to be State Trustees or a solicitor, get good professional advice, because they actually understand the law and the requirements, and that they can ask the right questions to make sure that you're properly informed and advised. And they also know how to write a will which will be valid and also reflect your wishes. So point number one is go to a professional will writer. Why State Trustees? Look, we've been writing wills for the last 70 years. We will still be here in 70 years' time. We're independent. We write more wills than anybody else. We have a dedicated team who just write wills. So I'd like to think they know their stuff, and that you're in pretty good and safe hands, and that we'll be looking after we can look after your will if that's what you want afterwards. So that's why professional will writer, yes, and State Trustees are a very good option.
To know. Now, life's not always straightforward. Can a will be changed if circumstances change?
Well, it can be changed. It can be changed by way of amendment
Oh,
it can also
sorry,
be
that question says, can it be
challenged.
challenged?
Oh, okay. Well, first of all, a will can be changed by either doing a new will or doing what we call a codicil, which leaves the original will on foot and then amends, makes certain amendments to it. So that's changing a will. But in terms of can a will be challenged, the answer is in Victoria, we don't have complete testamentary freedom. There is the legislative right for people to be able to challenge a will. By challenging a will, what I mean is you have someone who's asking for a share of the estate or an additional share of the estate. In order to succeed on one of those claims, which is sometimes called a family provision claim or a Part 4 claim or a TFM or Testator Family Maintenance claim, they're all the same terms for the same thing. In order to succeed on a claim, a person would have to show that the will writer owed them a moral obligation to provide for them, that there was insufficient provision made for them, they were an eligible claimant, and in certain cases that there was a degree of dependency. Now, since 2015, there's been a big change in our legislation. Prior to that time, anybody could claim against your estate. So historically, lots of claims. Since that time, we now, a person to bring a claim has to be an eligible claimant. Obvious people like partners and children, but also stepchildren, grandchildren, members of household, former partners who haven't had a property settlement. So those are the sorts of people who can bring a claim. But what that's actually saying is that the people who can no longer bring a claim are people like parents, like siblings, nieces and nephews, even the next door neighbour who provided a lot of assistance and support over the last 37 years, no longer can they bring claims. And that's made a significant difference in the amounts of claims that have been reduced quite dramatically. So the answer to the question is yes, claims can be brought in Victoria as a matter of right.
All right, I'll give you one more before we give you a bit of a breather.
Right.
Can someone include their overseas assets in their Australian will?
The answer is yes, but the yes bit is you can decide what assets are included in your will, and commonly wills are made without any limitations, so they cover whatever assets you've got wherever they're located, whether in Australia or elsewhere. But if you wish, you can actually confine the operation of your will to a particular territory like Australia. You might say, this will is only to cover my assets in Australia. And then it may be that you choose to do a second will in another country where you hold the other assets. If you do so, get advice. If you can have two wills, get advice to make sure that they're consistent with each other and don't contradict each other, okay? But I said yes, but. And the reason I said yes, but was because you can have a will in Australia that you intend to cover all of your assets elsewhere, but there are various countries that don't recognise Australian wills. They have their own form of inheritance. And we're talking about, parts of Asia, parts of Europe who have their own inheritance law. What I would say is, if you've got property in Commonwealth country, you won't have a problem. They will recognise our wills, but not every country will. So that if you've got assets in another country, you should get some advice, because the way that inheritance laws may work in other countries might be along family or cultural lines, and their concept of family might be very different to ours. They may not recognise domestic relationships. They may not recognise children born out of wedlock. Alternatively, they may rank parents equally with partners and children. So very different to the will that you might have intended. So yes, a will can cover property outside Australia, but get advice if that is your circumstance as to whether your will's going to operate successfully.
Good tip. So get some advice. Now, Jasmine, this is generally a real crowd favourite. Can someone include their pets in their will?
Yes, I think I touched on this a little bit before. You can definitely include a clause in your will dealing with your pets, and you can nominate a carer, a person who's going to take care of the pet, and that person will be given a certain amount of money to do that. So once again, a good idea to speak to whoever you have in mind and just discuss with them whether they're willing to take this on, and also what sort of care you might want them to provide. So for example, how often would your dog need to be walked? Would they have to engage a dog walker, etc.? So that would then inform how much money you're going to set aside for the pet.
And the last one for you, Jasmine, is a will for life?
Well, no, you can change that will and revoke it and do another will. And we recommend that you actually do that every 3 to 5 years or so, or when there's a big life event. So if you got married, if you had a child, or if you were to inherit a large sum of money yourself, maybe win tax lotto, something of that nature, I would suggest that you review and revisit your will and make the change.
Excellent. Thank you, David and Jasmine. Now we're going to jump into part 2 of the webinar today, which is the Q&A section. So we're going to be collating all the questions that will be coming through the chat. And just a reminder, you can complete your will online and book an appointment with our team. We'll leave the link in the chat for online wills and wills appointments. But please note that our will writing appointments are currently fully booked. So certainly lots of interest and certainly popular. However, you can register your interest and you'll be notified as soon as more appointments become available. So we'll just, as we're just collating a couple of questions here, see what's come through. David, I might throw this one over to you. What's the difference between online will and a consultative will?
Okay, thanks, Stuart. Well, online will is a document that you prepare yourself. It's like a will kit, but you do it via your computer or iPad. It differs to a consultative will. That is where you meet with a professional will writer who takes your instructions and then draws the document for you. Will kits and online wills can be very, very good, but they need to be read with a little bit of caution. They are really for circumstances that are straightforward, and where somebody is very confident that they're going to be able to follow instructions and that there's no capacity issues and the like. What I would say is if you're considering a will kit will or an online will, I would not do it in circumstances where you have complicated family structures, like if you're in a second relationship with children of a first relationship, or there's family disharmony. I think I wouldn't be doing it if I've got complicated assets like overseas assets or interest in businesses. I wouldn't be doing it if I'm wanting to establish trusts and things of that nature, life interests and discretionary trusts. And also, you've got to be practical things. If English is your second language, or sorry, not your first language, or if there's a risk that someone might question capacity, then I'm not sure that the will kit or the online will is necessarily appropriate. Having said that, for many, many people, where it's a straightforward will, where we're providing for partners and children and grandchildren with some legacies and the like, and appointing your own executor, then the online will kits are wonderful. They prompt you, they ask questions to prompt you and give you options, of answers, and they're very user-friendly. So online will you do yourself through the computer, and a consultative will is when you go and see a professional will writer.
Great summary. Thanks, David. Next question we've got here. Who takes over as the executor if the named executor dies soon after the death of the will maker?
Oops, I don't know about
that one come through, David?
Okay, I'll answer the question as best I heard it. My computer just said your line is unstable. So
would you like me to repeat it? I'm going to repeat it.
You'll
if
have
you
to
like.
take over and answer it for me, Stuart. But no, I think I got it. It was what happens if an executor dies shortly after the testator, which is the will writer. Is that the one?
Yep.
Correct. Is that what is it? Okay. I suppose the way I'd answer it is to say, look, there's a whole range of reasons why an executor may be unable to act when you've gone, and it might be because they've predeceased, it might be because they're living but they lack capacity, or they simply don't want to act. And that's why it's very important to have a good substitute clause, executive clause, so that someone else can come in. But one of the points I want to make, I think this question actually gives me the opportunity to say something. The wording that you use is very important. I've seen wills that say things like, if my executor A predecessors me, I appoint executor B. And you think, oh, that sounds good. Have a look at the example that you were just given, which was executor A actually survived the testator, but then died before obtaining a grant. That clause would not cover that situation because he did survive. The proper clause would have been, if he predeceases me or for any reason is unwilling or unable to act, and in that circumstance, even though the executor survived, if they then died before getting a grant, the substitute executor can step in. That's why words are very important. That's why sometimes, even if you think it's a relatively straightforward will, you should get some advice from a professional will writer. So hopefully that's answered that question.
We might give this one to you, Jasmine. Can someone contest a will years after it's been executed?
Well, usually you can contest a will 6 months after the grant of probate if you're bringing a claim for further provision. You could potentially bring it after that date if you got special leave from the court and if the estate wasn't distributed. But in most cases, most executors would distribute the estate 6 months after probate, so it would then be too late because all the money would be gone. So my advice is be aware of the timeframes if you are thinking of making a claim 6 months from the date of probate. So that's not the date that the person passes away. It's 6 months from the date that probate is obtained.
Okay. Now we've got one here. Do a husband and wife require separate wills, or can they have a joint will document? Open up to the floor.
Yeah, Jasmine, I don't know about you, but I'm very much separate wills. There's separate wills. A lot can change over periods of time. You can have wills that effectively mirror each other, a leave to each other and then to the children or whatever it might be. But there are lots of circumstances you have to consider, which is things like the change of asset ownerships when one person passes away, first of all. So you might have assets that are jointly owned. First one goes, and then you actually don't need to administer an estate at all if everything is jointly owned, then goes into the name of the survivor, and after that time, that person's will can operate. If you've got a joint will, you have issues if someone wants to change, vary, alter the will. You might have issues if there's a separation or the like. One might seek to revoke and the other not. I'm considering, of course, and Jasmine, you can help me here. I'm considering that there is a concept that you can have in other territories, one will for multiple people. But there's another concept, which is mutual wills, which is slightly different because it's basically where you've got couples who will say, I will make a will in the terms like this on the basis that you make a will in terms like that, and that neither of us are going to change our wills. You'd say, why would anyone do that? It's very common where it's second relationships and people have children to first relationships. So in other words, I'm going to make a will where I provide for my kids and your kids if you've got. So I'll leave it to you first, but if you've predeceased, I'll leave it to your kids and my kids, and you do the same. Because you can just imagine if you had those wills and the first person died and said, right, I'm now going to change my will. I'm going to cut out the former partner's children and just leave my children. So you do a concept called mutual wills, where it's actually a contract. I will make my will on the basis that you make your will in these terms and don't change it. And if you did go to change it, it's actually a breach of contract and people would have an action against you. But it's not common to have two people with one will, and I don't recommend it. In fact, I don't see it. And there's mutual wills, which is a different concept, but something that you really need to get good legal advice on. Jasmine, what did you think?
No, I agree. I think the much better option is to have two separate wills, and the two people do, they can leave it to each other and then to the children, but it's better to have it separate than to have that mutual will where there's a contract. Problem with that is one of the parties can spend all the money, so there's no point to having that contract then. I just don't think it's worth going down that path. I think it's much simpler to just do two separate wills.
I think I saw in the chat there was a question which I thought was a good one, which was, I've appointed my child as the sole beneficiary. Can I also appoint that person as my executor? And the answer is yes. And it's very common that people, partners, will appoint their other partner as the executor and to be the sole beneficiary of their estate. So yes, being a beneficiary does not in any way affect your ability to be an executor.
Okay, now I'm going to group the next two together under kind of will maintenance and taking care of it. So the question is, can I staple my will, and where can you deposit or store your will?
Okay, in relation to where can you store your will, there's a few things. State trustees have a will bank, so you can store it as state trustees without cost. If a solicitor writes your will, majority, not all, but the majority of solicitors will also store wills without cost. If you want to store wills yourself at home, make sure it is secure. And I'm talking about something like a safe. I'm not talking about a filing cabinet or folders, because there's a risk of theft, there's a risk of fire, all of those sorts of things. And also when you move, or no one knows where to find it. So you can do it at home, but you'd want to have something very, very secure. Some people more previously used to save custody packets with banks, but generally it'll be places like solicitors. You can even do it at the Supreme Court, but State Trustees has a will bank arrangement. In terms of stapling wills, okay, if you've got multiple pages, you actually will staple the will together. One of the problems is if you submit a will for probate and it has staple marks, the registrar is going to look at it and say, hold on, something was stapled to here. I need to know what it was, in case it was an extra page of the will, in case it was a codicil, in case it was something relevant to the will, and you'll need to tell me that I've got the whole will. So there's nothing wrong with stapling. In fact, you need to staple so we know I got the whole document. Generally, what people do when they've done a will is they'll get the will drawn and signed, they'll photocopy it, then they'll staple it, and then they'll certify it and provide copies and certifications for the client, and keep the original in a will packet or in our will bank or whatever it might be. So hopefully that's answered it.
It's actually quite a good segue into the next question, and it might be a little bit too specific, but I'll throw it to you anyway. What happens when a copy of the deceased person's will, signed correctly, as we've spoken about today, but the solicitor says it's not valid as they don't have the original and the original can't be found?
Okay. Proving a copy will or a missing will is quite a challenge. Your starting point is that the court requires the original will to be produced. If you can't produce the original will, you need to satisfy the court that the copy document is a document that's intended to be the last will. You'd need to give an explanation as to the searches that you've made, an explanation as to why the original might have been lost or misplaced. You need to call some evidence as to why you believe that that document was the last will. And it might be, you know, on a deathbed, Auntie Mabel said, "Oh, my will is in the blue folder next to my bed in the bedroom." And you go there in the, you know, in the blue folder next to the bed, there's a copy document. And it's a copy will, not the original. And you can't find the original, but at least you can produce some evidence to say that she thought that that was a document to operate. And the reason that you need all of this evidence is because the court will start from what's called the presumption of revocation. In other words, the reason you can't find the original will is because it was revoked, because it was torn up, it was destroyed, it was deliberately got rid of. So you have to provide evidence to persuade a court that that copy document actually reflected the wish of the will maker, that that was the valid document. And sometimes a document might go missing after the date of death. So that's probably more easily proved. Prior to the date of death, it might depend upon when it was last seen, when did you have last conversations, those sorts of things. Again, Jasmine, help me out. What else would you say recopy wills?
Yeah, it's possible to prove a copy will, but as David says, you have to be able to rebut that presumption. So you need evidence. You need to be able to satisfy the court that the will maker didn't deliberately destroy that will. So you would need, you know, evidence of conversations that were had, or certain events that took place in order to be able to do that. And that's quite an expensive exercise, but nevertheless, in certain cases, it can be done.
But there are a couple
Here's
of
one, I just popped up. I just was the one that popped. What happens when a husband and wife die? And I think it said together. Okay, all right. One of the reasons, so when you look at your wills now, your wills will generally have a provision in it which says in order for someone to take their share, they need to survive 30 days. Even if it doesn't have that written in the will, we have a Wills Act that basically imposes that obligation. So someone has to survive 30 days. So if they die together, now, first of all, you can normally determine if someone dies first in time. You know, let's say it's a car accident, someone dies at the scene, the other one's conveyed to hospital and dies, we know the order of death. With the bushfire cases was a difficult one where maybe someone died in the home, the other one was fleeing in a car, so you get to work out the order of death. But there are some circumstances where if you legitimately cannot determine the order of death, you simply don't know, and it might be because it's a fire and there's little evidence. There's a presumption that the eldest is presumed to have died first. But as I say, the effect of this is less probably important now with the survivorship having to survive 30 days, so you don't have two estates. Prior to 1997, it was simply just, you know, if you had that situation of husband and wife in a car accident, husband dies at the scene, wife dies the next day, you actually had to have two estates. These days, because they've got to survive 30 days, probably one estate if you've got your traditional will where they're leaving it to each other. So it's determined the order of death by evidence. If it can't be done, the presumption is that the eldest died first in time.
Okay, we might have time for a couple more. There are a couple of questions coming through in relation to fees. We'll be popping a link in the chat box for fees and things like that. Another one here. Can I include my superannuation in my will?
Maybe. The answer is superannuation is only an asset of the estate when the fund manager declares that it's an asset of the estate. And that's why you don't see super included in inventories when you're making an application for grant of probate. Now, part of your estate planning is that you may say to your fund manager, say, I want to make a nomination. And there are binding nominations or non-binding nominations. Your nomination might be to a family member, someone else, but it may also be to the legal personal representative. In other words, you want it to come to the estate and you make a nomination. Now, you have to look at your own superannuation policy to determine whether your nomination is going to be binding or not. Now, generally, if you're making a nomination to a dependent or a legal personal representative, there's the provision to do so, it will be binding. If you're leaving to someone else, it might be non-binding. In other words, you want the trustee to take it into account, but it's one of the factors they'll take into account. If there are other dependents who are missing out, you couldn't necessarily be guaranteed that they'll pay it to your nomination, but it's of persuasive value. Or you make no nomination at all. If there are obvious dependents, that's where it'll go. Otherwise, yes, it could come into the estate. And very often it does come to the estate, but I just want people to understand it doesn't always come to the estate. And it's an important part of your estate planning. So often people will have nominations for their superannuation, but then in their will, they might say something like, but if the super is paid to the estate, then I want my superannuation to go to, and then you say the same people that you had nominated. So one way or another, it finishes up where you want it to go. Because superannuation, of course, can be your largest, or after the home, perhaps your second largest asset. So it's quite significant in estate planning.
Yes, and I'll just add, you may not want your superannuation to actually come into your estate, because if your estate is open to challenge and there is a claim brought against your estate, then the super is in the estate. So you may prefer to have a nominated beneficiary in your super fund. Yeah,
agree with it.
I think that's a good question to finish on, and kind of really brings to life the importance of getting expert advice when completing your will and your broader estate planning needs. So that's all we have. That's all we have time for today. Thank you again for attending and submitting all your questions. If we didn't get to your question, keep an eye out on your emails for a follow-up in the coming weeks. To find out more about writing your will and your options with State Trustees, please visit statetrustees.com.au/wills. Thank you, David and Jasmine, for your expertise and time today. If you found this session valuable and interested in learning more about choosing an executor in your will, register for the next webinar on June 14th, where we'll share expert insights and tips on how to choose the right executor for your will. We'll drop the link into the chat box now, so you can go ahead and register for that session. Thank you everyone for attending, and have a great afternoon.